Ready? All righty. Good afternoon. Welcome to the March 25th, 2024 Government Operations Committee. Welcome everybody to this chilly Monday. Can I get an approval of the Monday, February 19th meeting minute?
So move. Second.
All in favor, say aye.
Aye.
All right. The meeting minutes from February 19th have been approved. And today we only have one agenda item, and it's short-term rental. Would you like to kick it off, or do you want me to proceed?
I can kick it off if you
Go
want.
ahead.
Yeah, so glad to be here. We're going to continue the conversation from last time. And so we've got a couple of things just update-wise based on questions y'all asked at the last GOC meeting. And so the Attorney's Office is going to share about state legislation. And then Assistant Planning Director Bruce Lonnie is going to share about the data that we've pulled from the system, as well as an updated timeline based on where we're at with everything. And then we can talk specifically about two other items that we think you need to decide on in order to move forward and send something on to the full mayor and commission. But with that, I'll kick it over to Attorney Jackson and Deputy Chief Attorney Hawkins for the update on state legislation.
I won't take too terribly long with this. If there are any questions, let us know, but I'll just kind of get the really kind of big high points. As some of you all might have heard, there is a bill pending in the General Assembly, House Bill 1121, that addresses short-term rentals.
Can I make a point there?
Yes, sir.
It's my understanding that did not make it over to crossover day, so I don't know if they might get attached to some Senate bill.
Yeah.
But it did not.
Yes, sir.
It did not go to committee or anything.
When I had checked it online, it had shown just a second reader in the House, but it didn't show anything.
I sent it to committee and it hasn't come out of committee, so.
Yes, sir.
Certainly, that is, if the Senate were to do something, they get attached to the amendment, then have to go back to the House.
Yes, sir.
And they've only got 2 days left.
Yes, sir. Yeah, so we're I mean, it's pretty short amount of time here that they would have left to do anything with this if they wanted to do anything. But just three kind of bullet points on this. Number one, this applies to short-term rentals that were in operation before a local government enacted regulations. And so what it does is it basically grants short-term rentals the right to continue operations if they meet certain criteria. And just kind of broad strokes, what those two criteria are is either the short-term rental was approved by the local government, or if the local, well, and this is talking about if you had previous regulation, the short-term rental was approved by the local government, or if the local government had no regulations, but the STR paid all applicable taxes during a certain time frame that's set forth in the legislation, it would be allowed to continue operating. So that's kind of the basic kind of overarching premise of the short-term rental. Certainly happy to answer any other questions anybody might have, but that's just kind of broad strokes what the legislation was, and Commissioner Hammond did a good job kind of explaining where it is in general.
Okay.
So anything that we do, if it gets passed, it supersedes anything that we do then. That's what you're pretty much saying.
Yes, Commissioner, it would. I think the intent of it would be to supersede local regulation and provide some state overarching state guidance about what they want to happen with short-term rentals. That's at least the intent by the General Assembly, as I read it.
Well, certainly, I think, you know, I don't know what would happen on their end, but on our end, I do think it's a home rule issue, and zoning is one of the most important things local government does. And I know GMA is keeping an eye on some stuff, and I'm sure ACCG is as well. So if something does occur, then I think you know, at some point we got to draw the line.
And that certainly that seems to be the intent of the General Assembly. As Commissioner Hammond mentions, there's obviously one of the home rule powers that cities and counties have in the Georgia Constitution is the power over zoning. The General Assembly can issue legislation concerning procedures around zoning, which is why we have a zoning procedures law. But substantively, that power belongs to local government.
And I think in the vernacular, when we talk about home rule, the legislature, it's also known as preemption. So there's something that the legislature is hearing about, that local governments are maybe getting into, maybe one or two, and they will do something to preempt that by putting other procedures in place. So when you hear GMA or some of the other folks talk about preemption, that's the same concept. So I'm sure.
All right, so any other substantive on 1121 HB?
No, sir, unless there are questions.
All right, with that, just want to thank our Chief Information Officer, Travis Cooper, for leading the charge on the short-term rental RFP software platform. And so we've been able to pull together data, and I know code enforcement and planning were integral on that RFP team. So we appreciate y'all's time and dedication to that. Now Bruce is benefiting from the data that's flowing from that. So Bruce is going to share a little bit about the data. I shared the overall number of 804 total properties in my email to y'all, but Bruce has got some more information behind that.
Yeah, and I want to be clear about what that 804 represents. So that's the number of properties that have been identified that had short-term rentals advertised from September 23 to September 22, 2022 to September 2023. So in the year prior to the enacting of the moratorium, those are the properties that listed for occupancy as a short-term rental. So that's not an accounting of who's operating now. It's not an accounting of anything more sophisticated than that. It's just for that 12-month window that becomes our starting point for a legal non-conforming list of short-term rentals. So of the 804 properties, a couple stats to throw around.
Can we see a copy? You got this?
Sure.
Is this what you put in the email?
All I put in the email was the total numbers.
Yeah.
This is more comprehensive.
So a couple things to take note of that you are probably going to want to know. 37% of the 804 are on record as having the homestead exemption. So that's interesting that 63% are potentially not owner occupied.
That's a lot.
Correct. It's we weren't sure what that number was going to be, but that's an important thing to understand. Other thing to break down is 54% of the Athens short-term rental owners were claiming homestead exemption. So just slightly over half of the people that have an Athens zip code were owner occupants of their short-term rental. Of the total of 804, 589 are zoned single family. So 73% of the properties on that potential legal non-conforming list are single family residential properties. And I've broken down what the other zones are that were represented there. Also want to make clear that since the adoption of the ordinance, we've been up and running. So we've been open for business to accept short-term rental home occupations since the Wednesday after the adoption. And we've also been open for commercial short-term rental applications to come in. To date, we've approved 2 home occupations. We've had 5 submitted, 3 of them we couldn't approve because they didn't either have the documentation or they weren't eligible for what they were applying for. But 2 have been approved and had home occupation permits issued. Nobody has applied for a commercial short-term rental to date. Couple things also to point out of the ownership data of these properties. Georgia owners, not surprisingly, are the bulk. So 750 Georgia owners were represented on this list. Of those, 551 have an Athens zip code. We have a handful of other surrounding communities that I thought were worth noting. But then out of state, it's really only 6.7%. So I think anecdotally going into this process, we thought maybe we'd see a lot of out of state investor type ownership. And there are some, and the distribution by state is listed at the bottom of the page. But it's not nearly what I thought it was going to be. Any questions about this data?
Have we looked at where they are geographical within our numbers for me?
To map it?
Yeah.
We will be doing that. We just finished proofing this list last week. So the next step would be to map it. Absolutely.
I'm curious to see where And then the majority of them located in one particular area. So,
That's right.
yeah,
Yeah, I'm with you.
yeah, we should see how that looks.
So I'm interested in this fact that only 14% of them are actually in RM zones.
Let me ask this question.
Yeah.
So almost 300 on record with homestead exemption status, yet there's 551, so the other 250, is that like both said they have an additional property or something?
Yes.
Mhm.
So it kind of proves that they do live in it.
But I think we heard a lot of that during the public comment prior to y'all taking action, that they own the house, they bought a larger house, but instead of selling the one they moved out of, they kept a loan to it for short-term rental. I think that's
I mean,
telling.
I do know of, some instances where families own a second home that kind of acts as a home for relatives, like they have parents or in-laws that come and stay for extended periods of time, maybe help with childcare. And those are the kind of instances where I feel like we should make room for these. I feel like there is a place, a limited and highly regulated place for them in single family neighborhoods. And I think we can come up with some stipulations that does allow them, maybe no more than they sleep no more than 4 guests. That would help with our party house problem.
Well, I know if you look, elections on the committee, we talked about this, we did look at the Atlanta law, which if they allow the homestead exemption plus one. Yeah. So, from that standpoint, I mean, I think we have with the existing ordinance of government, I think we ought to look at that. And hopefully, if you don't mind, Sharon, we got just some other things I wrote down here. I think we need some clarification as we're looking at the ordinance, clarification on a guest house. So if somebody has a structure and a guest house, if one party is renting it, it's not real clear in the ordinance about that. I know they said they can't run them both at the same time, but does it mean, to me, it means you can't rent them to 2 different parties at the same time. But what if the person that rents the main structure wants to utilize the other guest house?
Yeah. I brought it up.
Yeah. So there's that one, but also I think we need to look at the allowance of, and this seems to be a loophole in it, when you allow a long-term renter to get permission from the landlord to then do short-term rentals. I mean, we're not gonna go around checking leases, or if somebody, can you see what I'm saying? I mean, some of these folks, maybe these folks in Tennessee or Texas might say they rent to somebody, have somebody sign the lease, and I'm just speculating worst case scenario, I'm not saying they do it, but you see where other boats could be established in that regard. Where somebody signs a lease, says they live there full time, then turns around and short term rents. You see what you're going with that?
See, I do, part of the way we set it up, and the reason we set it up, and I'll certainly lean on our attorneys at the end of the table, but there is a dormant commerce clause issue out there that one of the things we've been talked to from Mr. Ellison about. I mean, we feel like the way we've got it set up, that would allow an out-of-state owner to own property in Athens and still utilize it as short-term rental through somebody that lives there full-time. It's a tenant covers us on that, from that standpoint. And we would, in the case that you've mentioned, I mean, there's going to be a requirement for the person that is applying for the home occupation as a renter to demonstrate to us through driver's license or something that in fact this is their permanent residence, and then it's being rented.
And we would require them to sign a legal affidavit, right? Those parties.
I mean, they got signed the permits themselves, and they're signing, and there would be a letter from the property owner authorizing the tenant.
I mean, I think that, there needs to be some clear indication that we intend to enforce these things. You know, and I could see there being, you know, a number of violations per year. If they get noise ordinance citation or, you know, multiple parking violations. You know, if there's real evidence that they're violating, even, you know, even a trash cans out, you know, just our quality of life codes. You know, and that could be a cause to withdraw their permit.
Well, before we get too much in gross, are there any more questions on the data? 804 seems low. Is that
It's what we were projecting all along. Brad said, you know, 700 to 1200 is kind of what we've been hearing. So it's within the realm of what we thought.
Well, and we anticipate, I mean, these were the ones that are showing up on the vendors list as having been advertised and marketed through one of those third-party sites. That's the reason, once we get this list completed and in a position to push it out to the public, that's what that 6-month window is for, is that if I've rented my house during that time period, but I did it privately through, you know, I did it without utilization of Vrbo or Airbnb or one of those, it gives me the opportunity to also apply to get put on that list. So we don't think this will be the last number. We fully anticipate there being people that come forward and fill out application to also be considered on the legal non-conforming list during that 6-month period.
okay?
So the one other thing we wanted to update you on before we talked about the sunset clause and the relief valve was just the updated timeline. So we wanted to make sure everybody was on the same page about what happens from here on.
Right, so as far as the legal non-conforming list, we've got probably a week of putting together the messaging on how we're gonna post this, who's gonna post it, what are the supporting documents you need to submit, if, like Brad said, you wanna make the case that you should be on this list, what are those things that will qualify you to be on the list? So once we get that pulled together with the help of the attorney's office, we should have that up in about a week. Then the 6-month clock will start. And for 6 months, it'll run and we'll take in information, we'll communicate with people, answer questions as best we can, guide them towards a permit if we can. That's been part of our education process is you don't have to rely on this legal non-conforming list. If you get a home occupation or you do it through plans review and get a commercial type legally, let's do that. And let's not rely on this. At the end of the 6-month window, we anticipate probably 2 to 4 weeks of wrapping up. We fully expect, just based off of other experiences with this, that in that last week of the 6 months, we'll get a huge load of people trying to get on the list. They'll kind of wake up and realize, you know, I need to do this really, really fast. So we'll probably have a few weeks after the closing date to finish up whatever paperwork and communication with those folks that come late to the process. Once we have perfected the list, that'll be the list. And that's when, by the way the ordinance is worded today, that's when that 24-month period would start, is the moment we've added that last property and feel like we have a perfected list.
That's important. So I thought the 6 months started when we voted. And so we got the data, take a week to wrap it up, and then 6 months from a week, that's when the 2 year will start. Okay. Can't do the math in my head. That would be
Sometime up to
October. Okay. Thank you.
after football season starts. So the timing of it, I think, maybe works out with those folks that are gonna want to go through the exercise, starting to realize what it does and doesn't mean for their forecasting of their rentals and their business model and those kind of things. I think we're in a good spot.
And any questions from the group? October. Okay. All right. Well, the big elephant in the room is the I don't, is that where we're transitioning to?
Yep.
The big elephant in the room is the planning commission recommendation. And I would like to open the floor for discussion on that. On people's thought, amendments, changes to that provision.
I think if we address some of the, I mean, if we address some of the other things like that land of the one plus homestead plus one, clarification on the guest house, then And you potentially knock out 250 people who may be interested in a sort of legal action phase. I think the relief valve that we spoke about last time may be a little bit problematic to handle administratively. So I mean, if you wanted to look at some other model that we utilize, certainly a special use permit, if what's is probably for, might be more aligned if we wanted to go down that direction. I mean, special use permit allows us, like it does with personal care homes and halfway homes, to look at the area and make sure it doesn't get overwhelmed with that type of use. Fraternities, sororities are the same way.
Yeah,
So
and there's a long list of criteria that we can consider, you know, to deny or approve properties.
So, fan of the relief valve because speaking of the attorney, it's a due process. We have to have due process for some of these STRs who may have some issues. But could you explain legally a relief valve?
Sure. I can explain that a little bit. So the concept of a relief valve is it kind of dovetails with a sunset provision. And so the thought process is, I know we've talked a little bit about this before, and you've heard public comment on this about, you know, if you put a sunset provision on legal non-conforming uses, and that is one thing I want to make sure that we're all reminded about, is that the sunset provision really applies to legal non-conforming uses. So if you put a sunset on legal non-conforming uses, at least some of those short-term rental operators may argue that they invested a certain amount of money in their short-term rental, and that 2-year time period is just not long enough for them to recoup that investment. And so under a relief valve provision, it provides some individualized due process. The STR operator can apply for, petition for basically an extension of the sunset provision on the basis that they need additional time to recoup their investment.
so much time do you give them, Jones?
I think that would be an individualized determination based on.
So if we do a relief valve for STRs to recoup their investment, are we going to do a relief valve for other businesses that perhaps are impacted by government ordinances that also impact their business?
Yeah, I would say that would obviously be up to the commission if y'all wanted to do that, but if certainly if you were working with a sunset, you could certainly consider that as part of a sunset if that's what the commission deemed that wanted to do.
Would y'all entertain a 5-year instead of 2-year or 10-year?
No, I don't know that. I don't know that. I mean, I think we ought to address some of the other things to look at those that are with the homestay exemption and answer some of the questions that we've already answered. I don't know.
So
I don't know. I mean,
So who would manage that process?
Yes, sir.
Yeah, so that's to me, I think that adds more to our staff. Who's gonna manage that process?
Yes, sir. So I think what, as a practical matter, you have some sort of application process where somebody would apply to, you know, I don't want to kind of delve into operations in terms of which department might handle it, but they'd apply to staff and say, you know, here's our information. This is why we need additional time on the sunset. And so there'd be, based on very strict criteria that would be in the ordinance, obviously. I mean, they would have to have ascertainable standards to apply that. But based on those criteria, there would be a determination as to yay or nay, you get an extension of, you know, you get the requested extension. If the STR operator was dissatisfied with that determination, there would be an administrative process where they could petition, you know, probably to the administrative hearing officer for an administrative hearing, which I envision would probably be somewhat of an evidentiary hearing, sort of trial-like, where they could present evidence to see whether they were entitled to that extension based upon the criteria that are set forth in the ordinance.
Would it be municipal court?
Yes, sir. Because our municipal court judge is also our administrative hearing officer.
But that's at the end of the due process though, but for the initial submission, I think is probably
Yeah.
what you were asking.
So with that said, would it make sense then for us to extend it out 5 years instead of 2? I mean, we're trying to figure out who we recruit. Cause, STR only recoup their monies on 2 year and finance for 5 year. Would it make sense to do a 5 year to reach that? I'm just asking.
Yes, sir. I guess what I would say in response to that, and I'm kind of looking at it from more of a legalistic fashion, I guess what I would say in response to that is if you extended the sunset provision, it would certainly lessen the argument of certain SDR operators to be able to say, hey, I didn't have enough time to recoup my investment. Obviously, the longer it is, the less people you presumably have that could credibly argue that they didn't have time to recoup their investment.
With the way housing prices are going, how is it that somebody's not able to recoup their investment? And again, I go back to the issue. I mean, if our government ever takes action on something like that, I remember when we banned smoking downtown or in restaurants, I mean, the argument then was, I'm not going to be able to make as much money. So we didn't go back and no one had a relief valve at that point in time to go back and say, I lost a lot of money because I wouldn't let people smoke in my bar or my restaurant. So you see where I'm going? I mean, we're going down a slippery slope when we're looking at it from that perspective. But, and also with administrative hearing part about it, there's no opportunity for, at least I wouldn't imagine there will be, maybe there is, maybe opportunity for people that are directly impacted by an SDR in a neighborhood whereas with a special use process, it does go through more of a public process and area that, certainly the commissioners and the planning commission vote on that. I'm not arguing for that at this point, but I'm just saying, to me, that makes more sense than a relief valve.
So to pivot a little bit, so right now for violators, not legal, non-conforming, but just noise, trash, yada yada, there'll be code enforcement and the police. So if this ordinance doesn't really say, the ordinance we just passed doesn't have punitive damages, not punitive. It doesn't have like, it doesn't punish a short-term renter who violated our noise and our noise, trash, etc. policies that we have on the books now. What are y'all thoughts on that?
I would like to see some mechanism by which, there is some punishment for just basic violation of ordinances. And if you violate, even a code enforcement ordinance, more than once within a certain period, you're at risk of getting that license taken away. I'd also like to see these properties, we require that they all have porch cams, ring cams or security cams that our officers have access to. I know you can sign up to allow our officers to access your security camera. I know of a couple instances where these things have been used, for potentially illegal purposes. It's evidence that they're like for drug deals to take place overnight.
Well, on Commissioner Link's first point, I think we learned this downtown. So there's certain licenses that the government provides that I believe at the time that they were called privileged, like an alcohol license. So there are infractions that you could weigh against issuing another license to a habitual offender. Is this the same principle to the commissioner's point?
Well, what we have on the books right now is more in the zoning. And
Okay.
so there are certain short-term rentals that, per the ordinance right now, are just an allowed use, a by right use.
Yeah.
And then there are some where you can issue a special use permit. Obviously, you consider the special use permit criteria for that. But we're not really issuing licenses for short-term rentals, where it's more,
But that permission is not privileged then through the zoning. Or can you do what she said in principle and say, if you get more than 3 infractions, whatever, in a given year, then you can't renew? Is that a possible, is that what you're saying, Commissioner Lee?
Yeah, I mean, I'd like to see it be less than 3 or 4.
Well, yeah, I was just throwing a number.
It does, yes. What House Bill 1121 had built in was, I think, three quality of life violations, and you could lose your license that was issued by the local government. That's something we'd have to look at. I don't think I've run into that exact scenario before. We're talking about it from a zoning perspective, certainly from a licensure perspective, to your point, Blaine. I mean, we could do that, things like that with alcohol licenses.
Well, I thought we now classify STRs as, like B&Bs.
So under the ordinance, we have specific definitions for short-term rentals. And so you have the basic definition of short-term rental, then you have short-term rental commercial and short-term rental home occupation. I don't want to speak out of school. I think they largely line up with where bed and breakfasts are allowed by right or allowed by special use, things like that. But I have to go back and look at the ordinance, but they are their own sort of category of use under our zoning ordinance.
I'd also like to see some requirement for posted signage or certificate. I know some communities require that. So, it's obvious to the rest of the neighborhood that this is a short-term rental.
So, I'm sorry, we're kind of all over the place. I think we're coming together. So let's go back to the Hanley Homestead Plus One, like Atlanta. So,
I think that's that approach. If you look at the properties that are on homestead, I think the total in Athens from people that live here in Athens. And that, to Melissa's point, I mean, I think Melissa was saying posting something so that somebody is having some problems and they would call. Certainly, if somebody's living here in town already and has a homestead exemption here in town, you're going to go and call. And if they have, like I remember the one gentleman that got up and spoke, he got him and his wife have lived here, they got married and then moved into one house and then they're renting out the other one. So I think that, I think you have more stake in the game if you know that you're impacting some neighbors and stuff like that.
so
And I will say, well, we'd have to look at that one too from the dormant commerce clause perspective, as Mr. Griffin mentioned, because there is some case law out there now. New Orleans had a scheme where homestead was kind of considered as part of that. So we need to check into that, but just to make sure we'd be on solid legal footing, but we certainly can do that and look at what the courts have said on.
So another issue that I've run into with STRs, even with the Homestead Plus One, is not all of the local people are like good stewards of short-term rental. They're renting, they're buying up homes in like low-income Black neighborhoods and folks, who are in need of housing, can't get housing because they get swept up by a couple of even more wealthier who can afford, these low-income housing. So
You just said 804, wasn't that big a number?
I'm thinking it's a lot more, but even with 250, I'm thinking that's still 250 homes that we can, could be rented or be purchased on their own, but it's worth going out there.
I think the geographical information that we're gonna look at, it was an idea to your point, where these homes are possibly located.
There's a lot in that.
Yeah, well, I'm probably right. Also, I want to go back to your point about the number of people.
In the SEO.
Yes, I would go with 6. Sometimes couples will come by. I would go with 6 may be a number. I'm asking, is that something that we can put into our provision as well? I want to say, if you own a short-term rentals, you don't allow up to 6 people.
And I wouldn't be enforced, just to.
Well,
That's where the security camera comes in.
Yeah.
If there's complaints of violation,
if there's a party going on and
we can get that information and get some record of who's coming and going.
Yes, sir. Certainly something we could look at. I mean, initially, I think that's something we could potentially do is some sort of limit. We have to look at it a little bit more. I will, the enforceability, part of that is difficult, I know, and that's always something that code enforcement runs into when you're trying to enforce these types of things.
So I think sometimes though, I do try to, sometimes people use the arm system, but, people know that, and then that's why I get caught, and, they get violated. It may stop people from trying to purchase actually, homes in there because of what we can't even 6 people, so that could deter some people possibly.
Well, and in in East Athens, the big problem is parking. And you get a short-term rental that has, up to 50 people, and you could very likely have 3 or more cars. And so, I think that's, I'm telling y'all, the number one issue I hear from constituents about is parking issues in our older income neighborhoods where, a lot of houses don't even have driveways.
Well, I think if you had a special process for those that are gonna be, for those that are, I guess, that would fall under the non-conforming after 2 years or maybe even less, that, at that point, then you could put you can put conditions on special.
Yeah,
So,
big time
and you also see where they're at, right? In relation to how we do, relative to how we do personal care homes.
Yeah, I mean, I agree with Mike, like, I think we should look at these in a similar process that we do personal care homes when it comes to single family neighborhoods.
And I'm saying that as maybe a possible way to address the 2-year sunset.
Yeah.
Any new ones that come online. We've got, you're informed, but if you're gonna be a new, regardless if you're part of that sunset or a new one, then you go through a special use process. So that we can have some, and so that the neighbors in the neighborhood can have some.
There's some public accountability.
There you go. That's what
I mean, granted, we might end up hearing 800 and something special use permit applications.
That's what I was thinking.
Yeah.
They'll come at the end of whatever the
Right,
provision
yeah.
time period you put on it, and then they're all gonna make applications.
Right, my concern, or do we, I think we need to think about this as commissioners.
Yeah.
Do we want to put that strain on?
Maybe what we do is make it really stringent by right requirements, no more than 2 guests and no more than, a certain number of rentals per year. And then those who do want to go can apply for the special use, because I'm thinking of the occasional properties where it's a family owned property and they rent it out on Airbnb to bring a little extra money when the family's not using it. But then there's the other ones that are like purely commercial properties.
So your data, from September to September, I'm assuming that most of the SCR is like over balloon when it came to the football season, right?
We didn't get that kind of breakdown
Okay.
where it's sliced it by month or time period.
I think anecdotally, football games and graduation are probably big generators.
Yeah.
Anecdotal.
That is something that we could talk to Rentalscape about, how we want to gather that data. Do we want to put a time frame, kind of timestamp on these postings? And again, it's just postings. It's not actual occupancies.
So we hear from staff and lawyers again.
Well, I just want to put this out there, what y'all brought up are new things.
Yeah.
And so I don't know if you're intending to come back as a GOC before you send this back to the mayor and commission. I think that's one thing that'd be helpful for staff to understand.
Yeah.
Okay.
Be clear, what path we're gonna go down.
Okay. So just throwing that out there. So, because the 2 things that I think as staff that we identified that we needed to hear from y'all, if we're going to move forward with a GOC report, is what do you think about the sunset clause and the file. But we've heard new things today. So I just want to make sure everybody's clear that these are things that staff will have time to work on and bring back to y'all at the next GOC meeting then.
So I'm still in favor of an extension of the sunset clause. And a relief valve. So nothing to go.
Okay. So the other elephant in the room, and I guess I can mention this, lawsuit. Where does that leave us? I mean, where are we? Well, I'm not sure what we can talk about, but I'm just saying. So, somebody have filed a lawsuit and stuff, so where, we're trying to make a decision. Where are we? Or how does,
Yes, sir.
so that's what I'm trying to say, but I mean.
Well, and I'm happy to provide just a brief update on that. So as you all know, a lawsuit filed related to the short-term rental ordinance. It's the mayor was served, I can't remember if it was last week or the week before. Do you remember what day it was, Austin? We have, Thomas Mitchell will be helping with us with that case. I believe you all know Thomas Mitchell from other cases that he's assisted us with. And so under Georgia law, you have 30 days from the date of service to file an answer. And so I suspect right now we'll file an answer. And that at that point, discovery starts. And discovery is the process by which people gather information from one another in a lawsuit. So that's just kind of high level where it's at right now. I can't speak for the plaintiffs in that case as to where some of these discussions might go, but my initial impression without going into it too deeply is I think the big point of contention from them is probably the sunset provision based on the counts in the petition. So
this body have no inkling to move from 2 to 5 years.
I do. I respect with my colleagues, Commissioner Hamby. I think we need to look at 5 years. Yeah. But always, with the democracies, whatever, we decide, I think it will help us hopefully along the way. What Attorney Hawkins talked about, then at least person say, well, you get 5 years to recoup your money. Sure, 5 years will be enough, regardless of what the housing market may be, because they can go, the housing market can go kaput if all we know. But
Well, so can if you invest in stocks, Dexter.
I know, I'm just saying, Mike,
Here we go.
I'm just saying I respect the disagree. That's all.
Is the government going to honor that investment?
I don't worry about the stock. What I worry about, I'm trying to protect this government. That's what I'm looking at. So again, I'm just
trying to protect some neighborhoods.
well, okay, and I am too. I think that's important. But again, I think we look at both sides. I respect and disagree. That's all.
I mean, I have mixed thoughts on it because there are neighborhoods that are dealing with some real issues, real disturbances, and they really need to leave it sooner rather than later. And I wonder if we can't go ahead and amend that ordinance to include these kind of punishments and threats to take away that license if we have these quality of life violations. And that would offer those reliefs when you do have problematic property.
I think if you address the homestead +1, you're going to help with the potential lawsuit aspect, because I suspect that would take a lot of people out of that lawsuit if you were to address that. But also, I think I'm agreeing with you to let's see what's at the next meeting. Let's see if we can get some consensus on some of these amendments that we can make, and if there needs to be clarification on the guest tax, for example, that needs to be one as well too.
Yeah, I mean, if there are consistently problematic properties, make sure there's a process by which you get the license taken away and restore some peace to the neighborhood. Like I said, I do believe there is going to be some of the capacity. I'm not necessarily opposed to them, but too many of them certainly has a negative impact on our housing market. And in some neighborhoods, just the number of guests coming and going has a negative impact on the surrounding community, especially when you have, really dense neighborhoods, limited parking. I think that up the regulations and establish a mechanism for removing licenses if we violate our work.
Okay, so it seems like we're looking for, real quick, so due process level, that's a given, we're doing that, correct?
in terms of the,
So even for the 2 year, someone has an issue, like I can't recruit money in 2 years, they can go through the, municipal court.
no, sir, right now, there's no, that's the relief valve idea, but there's no relief valve right now. Presently, under the sunset provision, all legal non-conforming uses have to come in compliance after the 2 year sunset expires.
That's opening up the government for more mayhem and lawsuits. I did pick a legal course in college, and one of the number one things they didn't talk about is due process. Everybody has to have the right and due process. I'm not a lawyer, but I just think it's very important that we even residents have a way to address, some of the issues that the government may impose on them. But right now, we don't have that mechanism.
No, sir, we do in terms of being able to get on the legal non-conforming list, but once that sunset provision, under the sunset provision, once that 2 years expired, you have to come in compliance.
And that's the main crux of the lawsuit, pretty much.
I would say is probably one of the biggest thrusts of the lawsuit. Yes, sir. That's one of the biggest complaints that they have is the sunset.
So
The other question for y'all is, do you want to keep the typical time in April that we would normally meet as a GOC, or do you want to set a meeting before that? That's another thing to talk about since there's follow-up work.
before that, we had a May original deadline, right? So
I think your goal was to finish this discussion this month and vote on it in April, not to get into the May vote cycle. Yeah. So it would be April agenda setting, May vote.
the question, if we do an early meeting in, would there be enough time in April to have your staff to do the work? And
Well, and remembering that, I guess, the way that process would work is recommendation comes out of committee, goes back to the commission. Commission then directs the planning commission to take up the item, to then bring the text amendment through. So this is starting the machine of an amendment coming out of this committee, but there's 3 steps before it gets back to the commission to vote.
okay, let's do another meeting before our regular scheduled meeting, if that's okay with y'all.
Fine.
So our regular scheduled meeting would be the 15th.
Yeah. Y'all want to meet the Monday before?
Because the goal would be to have something on the agenda setting cycle, right?
Yeah.
So that would be too close to agenda setting to achieve that. And then my other question would be for the attorney's office and staff, can we turn around what the GOC asked in terms of responses in time for that, an early April meeting?
Yes, sir, I think we can. We can put some resources on that. See, I think there were a couple of maybe legal questions raised that we could look at.
So let me ask you this then. We push it out? Or do we have, deadline we have to meet? I mean, are we trying to that deadline or can we push it out?
It's y'all's deadline. Yeah, I think y'all were just trying to get this going. And so you set that timeline for yourselves when you voted to try to get this to the planning commission certain times. But
Well, I'm willing to meet as often as y'all want and to get something done, but I think the main point is to get something done that folks feel, or most folks feel good about.
Yeah.
so, yeah.
The full, yeah, so I'm just thinking of the votes in the full mayor and commission as well. But that's some people behind the rail who have concern about the relief valve and the 5 years. But if we get it to you by May, will it still have the October deadline where the 6 months will kick in?
Yeah,
Okay.
we're moving forward with the short-term, the legal non-conforming short-term rental list. And that 6-month window, we're gonna work with the ordinance as it's worded. And everything I've heard you talk about hasn't really impacted that 6-month window. I haven't heard that discussion. And in the sunset clause, wouldn't start until that list is finished. So that period of review buys some time for discussion.
Okay.
When we look at it.
April 8th at 1 o'clock.
I'm not gonna be here. I'm taking our moms to see the eclipse.
Well, and hear what Bruce just said, why don't we just stick with the 15?
Right.
And then we can
Go out there.
adjust, yeah,
I mean, maybe could we do the fifteenth and possibly a follow-up the week
that's,
later?
maybe so, let's start with the 15.
There just won't be anything on the agenda setting,
Right.
agenda.
Right.
As long as y'all agree with that, then you're fine, because the agenda says the 16th.
Yeah. So if you push it out at least a month, it'll be okay.
I think we can come back and answer a lot of the questions that you've raised. The one that I think is super important, that I just want to make sure everybody understands, if we choose to pursue the relief valve, that's a big work effort to put that together. And that's not something that we can prepare in a week or two in terms of the mechanism, how it's going to work. You know, now whether or not there's a desire of the full commission to go that route needs to be voted on. But if it's decided that there's going to be a period, a fairly extensive period of time, I think that we would ask for it to put it together.
And follow with what Brad said, you know, if it's the will of this body to discuss and think about and craft a relief valve. Really the key component of that, I think Commissioner Hamby alluded to this a little bit, the criteria that you have to consider about recoupment of the investment. What are the factors that you're going to look at? That sort of thing, because there's going to need to be some really solid factors, some really solid guidance for staff and for the administrative hearing officer to review that. So that may take a little time, I suspect. This body may also have some thoughts about that as well. And so just to follow up.
And we don't think there is that expertise on staff now. So we don't have anybody on staff whose job is to figure out return on investment of property based on. So we're going to recommend third-party financial expert look at that. So I think that's part of this is we don't have people on staff whose job that is to do. So yeah, it is. And we don't have that financial expertise here.
It's exactly, not in our room.
So we just want to put that out there. Not that y'all made a decision on it, but we have some concerns about how to actually.
I mean, a special use permit process is something we already do and go for and know all the, go through and know all the criteria.
And I think the question that we will want to know, and I'm not sure I'm clear on it right now, is it the intent that the special use permit approach be used to address those properties on the non-conforming list? Or is it an approach to be expanded on moving forward with new ones?
I'm looking at expanding forward with new ones.
Because right now, we've got it set up where it's already special use, but once you get into commercial zones, then, you know, it becomes commercial STR and everything else is home occupation.
And I guess what I was looking for was in lieu of a relief valve for those that are non-conforming, then that's something that they can go through. But that's only if, you know, then we get offer like the home situation plus one or something like that. So because I recognize the work they may create on y'all.
There'd be additional criteria established for properties that are on the non-conforming list to be allowed to request a special use permit. They have to meet certain criteria in order to do that we don't have set up right now.
Right.
All righty.
But you lower the list, you see what I'm talking about, Brad? You lower the list if you're doing stuff in conjunction with that, like that on plus one, so
That's
it's still alive.
Yeah.
It's still.
The other thing I can tell you, with Bruce and I've had this conversation too, is that the language that you really said, some occupation, you know, our position on that right now, if you come in and apply for an home occupation, select one or the other. It's not for the main house sometimes, and you've got a guest cottage in the backyard, and sometimes it can't do them at the same time. It's basically, you've got to decide if you're going to operate as a home occupation, you're going to use the guest house in the back for your ATR, or are you going to use the main house? Given that you live there full time already and can't pick and choose. Now, if that's not what y'all are comfortable with, we need to modify the language.
I think taking a look at modifying that, because I could see where somebody's renting the main structure, they may want the kids out into the, you see where I'm going with it. I mean, I thought our intent was not to had two separate parties renting it out.
Right.
Yeah.
At the same time. But if there's
That's
one party,
clarification.
one party renting it out. Then there's
So-
no difference.
Our next meeting, we're just gonna have information. Cause I don't think we're ready to move on.
The other thing I heard y'all ask for was a map of where these properties are. So that's, hopefully something we can turn around too.
That's it.
But I will say, one of the things that we're gonna be really careful about, when we're publishing this list, we're putting out the tax parcel ID number and the address. That's it. We're not putting any other information out. We're not putting out maps. We're not putting out, owners' names. This isn't really meant to be a witch hunt. This is meant to be, it's just data.
Yeah.
Exactly.
We have to reach out about that anyway.
Yeah.
People's name on stuff. It's nice for y'all.
We just, if the intent is to be able to look up, if you feel like you've done it during that 1 year time period, you can look up the address. If your name's not on there, there's a process you go through with us to try to get your name on.
Exactly.
Well, business occupations are public records. And, certainly if you have home
Call out.
so that's what it is. But certainly.
Alrighty, South, you got anything else cut out for you? From the nose. Yeah, we're gonna meet on the 15th, 1 o'clock, starting time. Oh, you want to do 12?
No, once on.
1
We're
o'clock?
gonna do one.
Well, it's Gene's got an event today, so that's why we did it right. Motion to adjourn.
All in favor, say aye.
Aye.
All right, y'all.
Thank you.
No problem.